At 10:42 on the morning of January 26, 1998, emergency services were called to a house in Wilmslow, Cheshire. The house belonged to a solicitor and her husband, also a solicitor. A professional home, a quiet home. Inside, they found a mother with a dead baby. It was the second time in 14 months that the same woman had called for help and could not save her child. Her name was Sally Clark. Within weeks, she would be charged with murdering them both. The weapon, not a knife, not a rope, not poison. The weapon that sent Sally Clark to prison was a number, delivered by a knighted doctor, accepted by a jury, and trusted by a system that should have known better. But here is what makes this case unlike almost any other in the entire history of British justice. There was no murder weapon. There were no witnesses. There was no confession. Not a single person who saw Sally Clark harm either of her children. Not one. The medical experts who examined the bobbies could not even agree on how they died, or whether a crime had been committed at all. One defense pathologist at the original trial said, "I have never known a case where so many apparent findings have turned to dust on critical examination." What convicted Sally Clark was a number, a statistic, 1 in 73 million, delivered to a jury by a man who was not a statistician, based on a calculation that was wrong in every way a calculation can be wrong. And the most disturbing part, there was a second failure buried beneath the first, hidden evidence that pointed directly to a natural cause of death, evidence that existed since 1998. Evidence that no one told the jury about. Through the shadow lens, we examine the darkest crimes and the secrets hidden behind them. And tonight, the darkest crime in this story may not be the one that was ever charged. Tonight, we go deep into one of the most important miscarriages of justice in modern British legal history. A case in which grief was weaponized, statistics were corrupted, evidence was concealed, and an innocent woman was destroyed by the very institutions that were supposed to protect her. We will follow this story from beginning to end. From the night Christopher Clark stopped breathing in his cot, to the morning Sally Clark's cleaner found her dead on the floor of her home in Essex, 9 years later. Stay with us, because what emerges from inside the court records of this case will change how you look at expert witnesses, at criminal trials, and at what justice actually costs. Sally Clark was born Sally Lockyer on August 15, 1964, in Devizes, Wiltshire. She was the only daughter of Frank Lockyer, a senior officer with Wiltshire Constabulary, and a mother who worked as a hairdresser. She grew up in a home that valued order, duty, and the rule of law. Her father dedicated his career to it. She would follow. Sally studied law and became a solicitor. She married Stephen Clark, also a solicitor, and together they built a comfortable, conventional life. They settled in Wilmslow, a prosperous commuter town south of Manchester. Stephen became a partner at a Manchester law firm. Sally worked in corporate law. From the outside, it was precisely the kind of life that nobody examines too closely. In November 1996, Sally gave birth to their first child, a son. They named him Christopher. Friends described her as transformed by motherhood, overjoyed, devoted, entirely absorbed in this new life. Court documents describe Christopher as a healthy baby, active, growing. The kind of first child that makes new parents feel briefly, miraculously, that everything is going to be fine. On the night of December 13, 1996, Stephen Clark was at his firm's Christmas party. Sally was home alone with Christopher. The baby was 11 weeks old. She put him to bed, checked on him. He was not breathing. She called an ambulance. Paramedics arrived. Christopher was rushed to hospital. He was pronounced dead that evening. The death was examined by a home office pathologist, a consultant histopathologist based at Macclesfield General Hospital named Dr. Alan Williams. In his initial post-mortem report, Williams recorded the cause of Christopher's death as an infection of the lower respiratory tract. He noted that he had found evidence of infection in the lungs, and the death was consistent with this finding. In plain language, cot death, natural causes. The Clarks were devastated. They buried their son, and they tried, slowly and painfully, to find a way forward. In June 1997, Sally became pregnant for a second time. There was cautiousness in the Clark household. They had been through something no parent should survive. But there was also, quietly, hope. Harry Clark was born on November 29, 1997, 3 weeks premature. He was placed in neonatal care briefly, then went home. For 8 weeks, he appeared to be doing well. Then on January 26, 1998, the unthinkable happened again. Sally was home alone with Harry. She found him unresponsive in his Moses basket, slumped with his head forward. She called for help. The paramedics came. Harry could not be saved. He was 8 weeks old. Dr. Alan Williams performed the post-mortem on Harry. This time, his findings were very different. He concluded that Harry had been shaken to death. He noted retinal hemorrhages in both eyes, which he described, alongside tears in the brain and injuries to the spine, as classic symptoms of shaking. And then, in the move that would define this entire case, Williams went back to Christopher. He re-examined the material from Christopher's post-mortem. He reversed his original finding. What he had previously recorded as death from respiratory tract infection, he now concluded was probably smothering. He said he had found bruising and other physical markers that changed his view. He offered no satisfactory explanation for why his original assessment had been so different. The GMC would later call his inability to explain the change a significant failure. But in early 1998, this reversal was accepted, and it became the foundation on which Sally Clark would be prosecuted. Sally and Stephen Clark were arrested on February 23, 1998. On the advice of her lawyers, Sally twice refused to answer questions. The charges against Stephen were quietly dropped. Sally Clark alone was charged with 2 counts of murder. She was pregnant with their 3rd child at the time she was charged. She would give birth to a son who would grow up for the first years of his life without his mother. In the early stages of the investigation, both Sally and Stephen Clark were suspects. Police considered whether either parent, separately or together, could have harmed the children. Investigators evaluated the pattern. Both deaths occurred when Sally was home alone with the baby. Stephen had a solid alibi for both evenings. On the night Christopher died, he was confirmed to be at his firm's Christmas party. On the night Harry died, his whereabouts were accounted for. Police also examined whether there was a health visitor angle, whether anyone else with access to the children could have been involved. Each possibility was methodically closed. They considered whether this fitted the profile of what was then called Munchausen syndrome by proxy, a condition where a caregiver deliberately harms a child to attract sympathy or attention. The profile, they concluded, pointed to Sally. But here is where the investigation fractures. Because the decision to charge was made before the pathological science had been properly completed, and crucially, before a specialist post-mortem that the Clark family had themselves requested. Sally and Stephen Clark had asked for an independent specialist to review the deaths. That request was not honored. The system proceeded without it. When Dr. Williams performed the post-mortem on Harry, he did something that was standard forensic practice. He ordered microbiological and biochemistry tests. He took swabs from multiple sites on Harry's body, the stomach tissue and fluid, blood, lungs, bronchus, throat, and cerebrospinal fluid, and sent them to the laboratory at Macclesfield Hospital for analysis. The results came back within days. They were extraordinary. Staphylococcus aureus, a bacterium capable of killing healthy adults, let alone a premature 8-week-old infant, was found in 8 separate sites on Harry's body, including in his cerebrospinal fluid. The bacteria in the lungs and the cerebrospinal fluid were specifically noted as abnormal findings. The samples were then referred to Withington Hospital in Manchester and the Central Public Health Laboratory in Colindale, London, for further review. The response Dr. Williams received indicated that while contamination was a possible interpretation, the findings, particularly in the cerebrospinal fluid, showed traces of polymorphs, indicating that Harry had been infected while he was still alive, not after death. Medical experts who later reviewed this evidence told the Clark family that the most likely cause of death was what they described as overwhelming Staph aureus infection. They said no other cause of death was sustainably evidenced by the post-mortem. During the trial, the jury specifically asked whether any blood test results existed for Harry. Williams returned to the witness box to respond. He was asked directly about an entry in the notes referring to C and S results, culture and sensitivity tests, which is precisely what the microbiology tests were. His responses failed to reveal that these results existed. The jury never knew. They convicted without it. Williams's explanation, when he eventually faced the GMC, was that he believed the bacteria represented post-mortem contamination and were therefore not relevant. He said he thought the summary phrase he had written, "no evidence of acute infection or inflammation," had adequately covered the matter. He maintained this position even as other experts told the GMC that the finding of Staphylococcus aureus in the cerebrospinal fluid should have been disclosed regardless. The trial of Sally Clark opened at Chester Crown Court on October 11, 1999. The judge was Mr. Justice Harrison. Prosecution was led by Robin Spencer QC. Sally Clark arrived at court each day composed. She had by this time already buried 2 children. She had been on bail for over a year. She had given birth to a 3rd child. She had survived what no mother should be asked to survive. And now she was being asked to survive it again, in public, in front of a jury that would decide whether she was a grieving mother or a killer. The prosecution's strategy was clear from the outset. With no eyewitnesses, no confession, and disputed physical evidence, they needed to make the deaths themselves seem impossible to explain by any means other than murder. And to do that, they brought in Roy Meadow. Roy Meadow was, by any measure, a towering figure in British pediatrics. He had been professor of pediatrics and child health at the University of Leeds. He served as president of the Royal College of Pediatrics and Child Health. He had been knighted for services to child health care. He had also spent decades studying child abuse and had published extensively on what he called Munchausen syndrome by proxy. He had developed what became known, informally and approvingly, as Meadow's Law. 1 sudden infant death in a family is a tragedy, 2 is suspicious, and 3 is murder unless proven otherwise. Professor Sir Roy Mead. This dictum had been quietly shaping prosecutions of grieving parents for years before Sally Clark's trial. By 1999, it was treated in some circles as settled wisdom. By the time Meadow took the stand in Chester, he told the court, personally investigated 81 cases in which he believed cot deaths had in fact been murders. He had since destroyed the data. Meadow told the jury that the probability of 2 children from an affluent, non-smoking, 2-income family like the Clarks dying from sudden infant death syndrome was 1 in 73 million. He explained his methodology. He had taken a study called the CESDI-SUDI study, which estimated the risk of a single cot death in the relevant socioeconomic profile at 1 in 8,543. He then multiplied that figure by itself, 8,543 by 8,543, which he rounded to approximately 73 million to 1. To dramatize the figure for the jury, he offered an analogy. He said it was like backing an 80 to 1 outsider at the Grand National Horse Race, not once, but 4 years in a row, winning every time. The same accumulation of impossible luck. He also told the jury that with 700,000 live births in Britain per year, a genuine double-cot death in one family would only be expected to occur once every 100 years. The jury held that image. The judge, Mr. Justice Harrison, acknowledged its power but told the jury, "We do not convict people in these courts on statistics." And yet, as the Court of Appeal would later observe, the statistic, delivered with the grand national analogy, likely had a dramatic effect on the jury's thinking regardless. Here is the twist that changes everything in this story. The number was wrong, not slightly wrong, not arguably wrong, catastrophically, provably, inexcusably wrong, and the people who knew said nothing. In October 2001, nearly 2 years after Sally Clark had already been convicted, the Royal Statistical Society issued a formal public statement. They said there was no statistical basis for Professor Meadows' 1 in 73 million figure. They expressed serious concern at the misuse of statistics in British courts. The error was not subtle, it was foundational, and it had 3 separate compounding layers. Layer 1, the independence fallacy. When Meadows squared the probability of 1 cot death to produce the probability of 2, he assumed that 2 cot deaths in the same family are statistically independent events, like flipping a coin twice. Each flip has nothing to do with the last. But 2 cot deaths in the same family are not independent. They are deeply connected. Genetics, shared environmental conditions, shared lifestyle factors. A family that has experienced 1 cot death faces a statistically elevated risk of experiencing another, potentially between 5 and 10 times the baseline risk, according to some researchers. By squaring the probability, Meadows didn't just make an error. He produced the opposite of the correct answer. The actual risk of 2 cot deaths in the same family is not rarer than he suggested. It is substantially more common. Layer 2, the prosecutor's fallacy. Even if Meadows' calculation had been mathematically sound, it would still have been presented to the jury in a deeply misleading way. Meadows used a low probability of innocent explanation, 2 cot deaths, as though it were equivalent to a high probability of guilt. These are entirely different questions. Knowing that double cot death is rare tells you nothing about whether this particular mother committed murder, unless you also know how rare it is for a devoted, professional mother with no criminal history and no prior reports of child harm to commit premeditated double infanticide. That figure is also very rare. Meadows never calculated it. He never presented the other side of the comparison. When statisticians later modeled both scenarios, double cot death versus double infanticide in cases matching the Clark profile, the result was striking. Taking into account the actual prevalence of maternal infanticide in the United Kingdom, the mathematical probability that 2 infant deaths in a family like the Clarks represented murder rather than natural causes was approximately 4%, not 73 million to 1 against innocence. Roughly 96% in favor of innocence. The jury was given one side of a probability comparison and told it was the whole picture. It was not. Layer 3, the wrong study. The CESDI-SUDI study Meadows used was not designed to measure the likelihood of 2 cot deaths in one family. It was a study of individual risk factors. The researchers who conducted it later stated publicly that Meadows had used their data for a purpose it was never intended to serve. The Royal Statistical Society's statement said all of this clearly. Statistical errors of this type, they wrote, make a profound difference, potentially the difference between guilt and innocence. Yet by October 2001, Sally Clark had already been in prison for nearly 2 years. Her first appeal, heard in October 2000, had failed. The first Court of Appeal acknowledged the statistical evidence was flawed, but ruled the other medical evidence was sufficient. She stayed in prison. And the man who gave the evidence, he said nothing. He cited legal advice. He cited professional etiquette. He waited. On November 9, 1999, the jury returned. By a majority of 10-2, meaning 2 jurors held out for acquittal, Sally Clark was found guilty of murdering both Christopher and Harry Clark. 2 jurors had not been persuaded. 2 people in that room resisted the number, resisted the authority of the expert witnesses, and voted for this woman's freedom. They were outnumbered. Mr. Justice Harrison handed down the mandatory sentence, life imprisonment on each count. Sally Clark stood very still in the dock. Stephen Clark, watching from the gallery, described the moment as silence before a collapse. What happened in the hours after the verdict set the second phase of Sally Clark's ordeal in motion. The British press did not cover the story as an uncertain legal matter. They reported the verdict as fact and the woman as guilty. Newspapers portrayed her as a cold, career-driven solicitor, a woman the prosecution had described as a lonely drunk who had seen her bobbies as obstacles to her lifestyle. Her composed demeanor in court was interpreted not as dignified grief, but as the absence of maternal feeling. Her profession was held against her. Her success was held against her. The tabloid version of Sally Clark was a monster in a well-cut suit. And this portrayal followed her into prison. Sally Clark was sent first to HMP Style, a women's prison near Wilmslow, in the same county where she had lived. Then to HMP Bulwood Hall in Hockley, Essex, where she would serve the bulk of her sentence. Her background made her a target, a solicitor, the daughter of a police officer, convicted of killing her own bobbies. In a prison system where child killers occupy the lowest rung of the informal hierarchy, she was treated accordingly. Her husband Stephen, who had never wavered for a single day in his belief in her innocence, gave up his partnership at the Manchester law firm to work as a legal assistant closer to the prison. He sold the family home to pay the legal bills. He brought their surviving son to visit his mother through prison glass. In April 2001, Sally made a video from inside Bulwood Hall, proclaiming her innocence. It was met with widespread mockery and skepticism from the press. The solicitor John Batt, who was part of her defense team and later wrote a book about the case called Stolen Innocence, described it plainly. Imagine being in jail where everyone thinks you are the scum of the earth. The thick end of it is that she lost 5 to 6 years of her life in what was state-sponsored torture. In October 2000, Sally Clark's legal team mounted the first appeal. They challenged the statistical evidence directly. They argued Meadows' figure was scientifically indefensible. 3 appeal court judges heard the argument and dismissed it. Their ruling was extraordinary. They acknowledged that the statistical evidence had been flawed and should not have been presented to the jury in the way it was. And then they said it didn't matter, because the medical evidence from Dr. Alan Williams and the other expert witnesses was, in their word, overwhelming. Overwhelming. Without the suppressed microbiology results, without the Staphylococcus aureus data, without the finding that had been sitting in a hospital file at Macclesfield since February 1998. The court never saw it. The defense had not yet found it. The first appeal failed. Sally Clark stayed in prison. And here is the detail that makes this failure so damning. The evidence that would free her had already existed for over 2 years by the time that appeal was heard. It was in a hospital file. Nobody had looked. After the failed appeal, Stephen Clark did not stop. He requested access to every medical record, every laboratory report, every post-mortem file connected to both his sons. He worked systematically through over 1,000 pages of hospital documentation. Buried in the records from Macclesfield Hospital, he found the microbiology results, the tests Dr. Williams had ordered, the findings Dr. Williams had never disclosed. In 2002, the Criminal Cases Review Commission, the independent body that investigates potential miscarriages of justice, referred the case back to the Court of Appeal, this time with the evidence that should always have been there. The second appeal opened in January 2003. This time, Claire Montgomery QC represented Sally Clark. She placed before the court the evidence that had been withheld. Montgomery told the judges that Dr. Alan Williams had possessed the microbiology results since February 1998, since the very beginning of the investigation, that the laboratory at Macclesfield Hospital had reported Staphylococcus aureus at 8 separate sites on Harry's body, that the bacteria in the cerebrospinal fluid were accompanied by polymorphs, indicating infection during life, not post-mortem contamination. That medical experts who had reviewed the findings said overwhelming Staph aureus infection was the most likely cause of Harry's death, and that no other cause was sustainably evidenced. The prosecution, faced with this, conceded on the second day. Crown Counsel told the court that the prosecution no longer sought to uphold Sally Clark's convictions. Lord Justice Kaye, presiding, was unsparing about Williams. He said Williams had failed to share with other doctors investigating the cause of death information that a competent pathologist ought to have appreciated, needed to be assessed before any conclusion was reached. He added, "We have no doubt that the resulting convictions are, therefore, unsafe and must be quashed." On the statistics, the judges went further. They said Meadows' figure had been dramatic evidence that one could confidently expect to have a dramatic impact on the jury. They said that if the statistical arguments had been fully and properly presented to them, they would, in all probability, have allowed the appeal on those grounds alone, even without the new pathology evidence. In other words, either failure, the statistics, or the suppressed evidence would have been enough to free her. There were two independent paths to her wrongful conviction. Both required her to be imprisoned before either was corrected. Sally Clark had served 3 years, 1 month, and 26 days in prison for 2 crimes that had not been committed. Today is not a victory. We are not victorious. There are no winners here. We have all lost out. We simply feel relief that our nightmare is finally at an end. We are now back in the position we should have been in all along and plead that we may now be allowed some privacy to grieve for our little boys in peace. Sally Clark, January 29, 2003. Here is what the establishment did not want examined. Sally Clark was not an isolated miscarriage of justice. She was a single woman inside a systemic pattern, and the pattern had been operating for years. Attorney General Lord Goldsmith, responding to Sally Clark's release, ordered a review of hundreds of cases in which convictions for infant deaths had relied on expert medical testimony, particularly testimony from Roy Meadow. What that review found was staggering. In April 2002, Angela Cannings, a mother from Wiltshire, was convicted of murdering 2 of her 3 bobbies. Roy Meadow had testified against her. The case bore striking similarities to Clark's. No physical evidence of violence, a loving mother described by everyone who knew her as devoted, and medical evidence that could not definitively establish murder. In December 2003, just months after Clark's release, the Court of Appeal overturned Cannings's conviction. The court held that genetic inheritance was a realistic explanation for the deaths in her family, and crucially, ruled that no mother should be convicted of murdering her children when the only evidence is that medicine cannot explain the cause of death. Canning, speaking after Sally Clark's death in 2007, said, "I'm so angry. This lady suffered so much. She had found it increasingly difficult to accept what had happened to her. She was very vulnerable." In June 2003, the Crown Prosecution Service used Meadows' testimony against Trupti Patel, a pharmacist from Berkshire accused of murdering 3 of her bobbies. The trial lasted several weeks. The jury took less than 90 minutes to return a unanimous verdict of not guilty. Afterward, a spokesperson for the prosecution was reported to have said that the Crown would still be very happy to use Meadows' evidence in future trials. They were not embarrassed. Not yet. Donna Anthony had already served 6 years in prison after being convicted of murdering her son and daughter, a conviction in which Meadow had also testified. Her conviction was overturned on appeal. 6 years for nothing. In every one of these cases, no physical evidence of violence, no witnesses, no confession. Women whose neighbors, friends, and families described them as devoted mothers. And in every one of these cases, Roy Meadow, standing in a courtroom, telling the jury that nature could not explain what had happened. The review prompted by Clark's case eventually examined 297 individual convictions for infant death. Only a relatively small number of appeals were actually launched, but the majority of those that were launched succeeded. In addition to the overturned convictions, the law itself was changed. No person could henceforth be convicted of murder on the basis of expert testimony alone. On June 21, 2005, Professor Sir Roy Meadow appeared before a General Medical Council Fitness to Practice Tribunal in London. The GMC's counsel, Robert Seabrook QC, told the panel that Meadow had either failed to understand what he was doing or had used the statistical information carelessly in support of a predetermined conclusion. He had acted beyond the limits of his expertise. He had abused his position as a doctor. On July 15, 2005, the tribunal found him guilty of serious professional misconduct. He was struck off the medical register, removed from the list of registered physicians in the United Kingdom. It was only at this hearing that Meadow made his first public apology for the effect of his evidence. He said he had been advised by lawyers not to speak earlier. He cited professional etiquette as another reason for his prolonged silence. The failure to apologize and his refusal to admit he was wrong was, according to Frank Lockyer, the central reason Sally Clark's father had filed the GMC complaint in the first place. Lockyer, a police officer who had dedicated his career to the rule of law, watched the system that had failed his daughter and decided that if the system would not act, he would make it act. He filed the complaint himself. However, and this is a bitter detail, in February 2006, the Court of Appeal reinstated Meadow by a 2-to-1 majority. The majority found that an expert witness acting in good faith should not face professional ruin for honest errors. The dissenting judge disagreed. The result: Roy Meadow returned to the medical register. Dr. Alan Williams faced separate GMC proceedings in 2005. He was found guilty of serious professional misconduct for failing to disclose the microbiology results on Harry Clark. He was banned from home office pathology work and coroner's cases for 3 years. He was allowed to continue working as a consultant histopathologist at Macclesfield General Hospital. He appealed even this limited sanction. The High Court upheld the GMC's finding. The judge noted that it was troubling that a pathologist could, in Williams's own framework, self-certify a test result as irrelevant and never disclose it, without anyone being able to challenge that decision. He found the sanction appropriate. Williams continued to maintain that the bacteria were contamination. He said that if the defense had wanted the results, they should have asked. He never acknowledged what his silence had cost. Sally Clark was released. Her convictions were quashed. The Court of Appeal described her case as one of the worst miscarriages of justice in recent years. Journalist Geoffrey Wansell called it one of the great miscarriages of justice in modern British legal history. She went home, and she did not recover. Her husband Stephen told reporters after her release that she would never be well again. He was not exaggerating. He was a solicitor who understood precise language, and he meant precisely what he said. In the years that followed, Sally Clark was diagnosed with a cluster of severe psychiatric conditions. The inquest into her death recorded the clinical language: enduring personality change after catastrophic experience, protracted grief reaction, alcohol dependency syndrome. Read those terms carefully. Enduring personality change after catastrophic experience is the clinical recognition that what was done to this woman changed her, permanently and irreversibly, at the level of who she was. Protracted grief reaction acknowledges that she never stopped grieving for Christopher, for Harry, and for the years taken from her while their deaths were treated as murders she had committed. She attended hospitals and clinics. She and Stephen worked with full support. She tried. She never returned to practice law. A family spokeswoman said, Sally was unable to come to terms with the false accusations, based on flawed medical evidence and the failures of the legal system, which debased everything she had been brought up to believe in and which she herself practiced. This is the sentence that matters most in understanding what happened to Sally Clark. She had been raised by a police officer. She had become a solicitor. She had believed in the justice system not abstractly, not naively, but professionally, as someone who had devoted her working life to it. The justice system did not just imprison her. It destroyed the foundations of everything she had been taught to believe was true about the world. On the morning of March 16, 2007, Sally Clark's cleaner arrived at the family home in Hatfield Peveril, Essex. She found Sally collapsed and unresponsive. Paramedics were called. She was already dead. Her husband Stephen was out of the country on a business trip. Her surviving son had been taken to school that morning. At the inquest held in Chelmsford, the coroner's officer John Febby testified that post-mortem tests showed a concentration of alcohol in Sally's blood that was 5 times the legal drink-drive limit. Home Office pathologist David Rouse concluded the cause of death was acute alcohol intoxication. The coroner returned a verdict consistent with accidental death. There was no note, no evidence of intent. She was 42 years old. John Batt, the solicitor who had worked alongside her defense and written about her case, spoke to her the week before she died. He said that she would have good days and bad days, but that he did not think you ever truly recover from something like that. From being the woman everyone thought was the scum of the earth. From losing 5 to 6 years of your life to what he called, without hyperbole, state-sponsored torture. Angela Cannings, the other wrongly convicted mother, heard the news and said she was shocked and stunned. That Sally had suffered so much. That nobody from the system, no social services, no police, no doctors, had come to either family after their release to check whether they were all right. That they had been expected to simply go home and be fine. It's almost, oh well, she's free, go home to your husband, you will be fine. It's so wrong. Angela Cannings, 2007. The men whose evidence destroyed her never spent a night in a cell. Sally Clark spent 1,126 nights in one, and then she spent 4 more years dying from what had been done to her. Cases like Sally Clark's do not only live in courtrooms, they live in the architecture of how societies decide who to trust. We have built systems to process devastating human events, to examine the death of a child and determine with legal certainty whether it was a crime. That is rational. It may even be necessary. The alternative, a world where infant deaths are never investigated, is also dangerous. But the Sally Clark case exposes something that rational systems can produce when their assumptions fail: a cascade. When one expert steps outside the boundaries of their expertise, and nobody in the room has the knowledge to stop them. When evidence is withheld, and nobody in the room thinks to ask for it. When an appeal court rules that flawed evidence doesn't matter because there is other evidence, without knowing the other evidence was also compromised. Each failure was understandable in isolation. Together, they destroyed a woman. Roy Meadow was not a liar in the simplest sense. He was a man who had spent decades in the orbit of child abuse, a world where the most important skill is pattern recognition, and where the failure to recognize a pattern can cost a child's life. He had developed over many years a certainty that multiple infant deaths in one family meant murder, and certainty, dressed in a knight's credentials, is almost impossible for a lay jury to challenge. But certainty without evidence is not expertise. It is authority. An authority that cannot be questioned is dangerous in exactly the proportion of its prestige. The GMC's tribunal said it clearly. By giving erroneous and misleading evidence, Meadow had undermined public confidence in doctors who play a pivotal role in the criminal justice system. The consequence of his authority was not just that Sally Clark was convicted. It was that dozens of other women were too, and that a generation of juries trusted expert witnesses more than the evidence in front of them. Williams's case is harder to characterize, and in some ways more troubling. He made a professional judgment that the bacteria in Harry's cerebrospinal fluid were post-mortem contamination. Some respected pathologists agreed with him. Others disagreed profoundly. The disagreement was legitimate. But the decision to keep that judgment to himself, to never share the results, to never let the defense see them, to never let another expert evaluate them, that was not a matter of scientific interpretation. That was a choice. And when the jury specifically asked whether blood test results existed, and Williams returned to the witness box and failed to mention them, that was not an oversight. The High Court judge who upheld his GMC sanction said it was troubling that a pathologist could self-certify a result as irrelevant and thereby prevent anyone else from ever knowing it existed. That is precisely the right word. It is troubling. And it is the reason disclosure rules in forensic pathology were subsequently tightened. The review ordered after Sally Clark's release examined 297 cases. It found problems in some. It overturned convictions in a handful. But not every historic conviction is reviewed. Not every family has a Stephen Clark, spending years systematically reading through 1,000 pages of hospital records until he finds the one page that proves his wife's innocence. How many cases went unreviewed? How many women finished their sentences before anyone looked? The system does not answer this question easily, because the system has no institutional incentive to find all the people it has harmed. It finds the ones it is forced to find when someone forces it. And the Bobbies, Christopher, Harry, and the children at the center of all these cases, they were never truly understood. Their deaths were categorized as crimes to be prosecuted. When the prosecution collapsed, the deaths became simply unresolved. There was no subsequent effort to understand why two healthy Bobbies in the Clark family died. The science of sudden infant death syndrome remained then, and remains now, incomplete. That incompleteness was the space in which Roy Meadow operated. Certainty filled the gap that knowledge left open. Cases like this remind us how deception, and in this case, the deception was not conscious malice but the self-deception of authority, hides in ordinary places, in a doctor's confidence, in a statistic that sounds too precise to question, in a jury that trusts the man with letters after his name more than the woman in the dock with everything to lose. Lesson 1. Expert witnesses are not infallible. Roy Meadow was a distinguished pediatrician who stepped into statistics, a field he did not adequately understand, and delivered a number that sounded like certainty. Nobody in that courtroom had the expertise to challenge him in real time. Every justice system must ensure that expert witnesses are cross-examined with equal expert authority. The authority of a title is not evidence. Lesson 2. Statistics can be weaponized against the innocent. The prosecutor's fallacy is not an obscure concept. It is a known, documented, repeatedly warned about error in legal reasoning. The Royal Statistical Society had been flagging it for years. The fact that it passed through a full criminal trial, a first appeal, and 2 years of imprisonment before anyone in authority acted on it reveals a systemic innumeracy at the heart of the British legal establishment in the late 1990s. Lesson 3. Suppressed evidence is not a footnote. The Staphylococcus aureus findings in Harry's cerebrospinal fluid were not a minor detail. They were the pivot on which the entire second appeal turned. Dr. Williams possessed those results from February 1998. The trial was in November 1999. The first appeal was in October 2000. At every stage, the evidence sat in a file at Macclesfield Hospital. Disclosure is not optional. It is the foundation of a fair trial. Lesson 4. Grief is not evidence. Investigators and media alike interpreted Sally Clark's composed demeanor as suspicious. Her professional success was held against her. Her apparent coldness became, in the tabloid and prosecutorial narrative, proof of something dark. But grief is not linear. Shock does not always look like what we expect it to look like. And treating the absence of performed emotion as evidence of guilt is not forensic science. It is prejudice. Lesson 5. Exoneration does not restore a life. The Court of Appeal quashed Sally Clark's conviction. The GMC found Roy Meadow and Alan Williams guilty of serious professional misconduct. Reforms were made. Laws were changed. And Sally Clark died at 42 with alcohol 5 times the legal limit in her bloodstream, having never returned to law, having never found her way back to the woman she was before the system took her apart. Exoneration is a legal process. It is not a human one. The system has no mechanism and apparently no institutional interest in restoring what it takes. We began with a number, 1 in 73 million, the number that was wrong. The number that went unchallenged. The number that sent Sally Clark to prison for 3 years and drove her, slowly and undeniably, toward the morning in 2007 when her cleaner found her on the floor. But the real subject of this story is not the number. It is the silence around it. The silence of Dr. Alan Williams, sitting on laboratory results that showed a natural cause of death for 5 years. The silence of an appeal court that reviewed flawed evidence and called it sufficient. The silence of a system that freed Sally Clark and then left her to manage what it had done to her without support, without acknowledgement, without anyone coming to the door. Angela Canning said it. Nobody came. After they were freed, nobody came to see if they were all right. In a system that devotes enormous resource to prosecuting the wrong people, there is apparently no budget for checking whether those people survived. Now, I'll tell you something most investigators miss, and why it cannot be overlooked. This has to do with 7 warnings this case leaves for the world. Before we close this case, before we return Sally Clark to the history she was robbed of being remembered for, we need to stay in this room a moment longer. Because the death of Sally Clark was not the end of a story. It was a signal, a warning that nobody wanted to hear, dressed in the form of a woman who could no longer speak for herself. This case did not happen because the law failed once. It failed 6 times, in 6 different rooms, by 6 different mechanisms, and every one of those mechanisms is still in use today. So tonight, through the shadow lens, we examine not just what happened, but what it means, what it warns, and why the warnings cannot be overlooked. Because the system that destroyed Sally Clark was not broken, it was functioning exactly as designed. And that is the most terrifying thing about it. Here is the first thing this case warns us about, and it is the most human of all the failures, which is precisely why it is the most dangerous. Roy Meadow walked into a courtroom with a title, a career, and 4 decades of accumulated authority. He had been trusted by courts before. He had been right before. His status had been validated so many times by so many institutions that, by 1999, the act of questioning him had become almost socially impossible. He was not questioned, not adequately, not by the judge, not by the defense, not critically by any statistician, because no statistician was in the room. The jury convicted on the authority of these doctors and on the collective authority that medicine wields in our society. The doctors being judged acted like zealots. British Medical Journal Review of Stolen Innocence, 2004. Zealots, not liars. Zealots, people whose certainty had outgrown their evidence. People who were so experienced in finding child abuse that they had begun to see it everywhere, including in a mother's grief. The prosecution in this case built a theory before they had evidence. They found a pattern, 2 dead Bobbies, 1 mother, and they went looking for facts to confirm it, rather than facts to test it. That is the definition of confirmation bias, and it is not unique to this case. It is not unique to Britain. It is a failure mode that sits inside every investigation, in every country, in every era. The same brain that makes a detective brilliant, the brain that recognizes patterns faster than logic can explain, is the same brain that, unchecked, constructs a story and then makes the evidence fit. Why it cannot be overlooked? Because expert witnesses are present in courtrooms right now, all over the world. And in most of those courtrooms, a juror cannot tell the difference between genuine expertise and confident overreach. The credential is the same. The voice is the same. The suit is the same. The only difference is whether the evidence beneath the authority is real, and the jury has no way to check. This warning says, authority is not evidence, and a system that treats authority as evidence is not a justice system. It is a prestige contest. Let us be very specific about what happened in that Chester courtroom in October 1999, because the mechanism is still being used today, and most people, including most lawyers, would not recognize it if they saw it. Roy Meadow gave the jury a number, 1 in 73 million. He told them it was the probability of 2 cot deaths in a family like the Clarks. The jury heard it as the probability that Sally Clark was innocent. These are not the same thing. They are not even in the same category of question, and the gap between them is the gap in which Sally Clark was buried. Statisticians call this the prosecutor's fallacy. It works like this. You take a rare event, double cot death. You calculate how unlikely it is, 1 in 73 million, or whatever figure you arrive at. And then you tell the jury, since this innocent explanation is so unlikely, the guilty explanation must be the correct one. But this ignores the other side of the equation entirely. How likely is double infanticide, maternal double infanticide, in a professional household, with no prior incidents, no witnesses, no history of abuse? The rate of that event is not 1 in 73 million. Forensic statisticians who calculated it using the same UK crime data found it to be closer to 1 in 2 billion. Meaning, when you actually compare the two rare events against each other, the probability of Sally Clark's guilt was not overwhelming. It was approximately 4%. The real numbers, 2 cot deaths, estimated 1 in 100 after accounting for genetic environmental dependency, Professor Ray Hill, Salford University, 2004. Double infanticide in matching demographic profile, approximately 1 in 2 billion. The ratio makes the likelihood of Sally's innocence around 96%. The jury was shown one side of a coin. Meadow showed them the tails and told them there was no heads. And the judge, Mr. Justice Harrison, who told the jury not to convict on statistics, still allowed the grand national analogy to stand, still allowed that vivid, cinematic, utterly misleading image to live in the jury's imagination throughout their deliberations. The Royal Statistical Society, Britain's most authoritative body on statistical science, issued a formal statement saying there was no statistical basis for the figure. They wrote to the Lord Chancellor. They spelled out the error. Their statement was issued in October 2001. Sally Clark had been in prison for nearly 2 years by then. Statistics must be treated with the utmost care. Such evidence should only be permitted from a statistics expert, and only if the judge is satisfied that it really is relevant to an issue. Medical Legal Journal, 2004. That recommendation was made after the fact, after the damage, after the woman. Why it cannot be overlooked? Because statistics are now more prevalent in courtrooms than ever. DNA probability figures, forensic likelihood ratios, digital data analysis. Juries in 2025 are confronted with numbers that are harder to scrutinize than Meadow's multiplication, and they are still not routinely given statisticians to help them interpret what those numbers actually mean. A number is the most seductive form of authority in a courtroom because it sounds like it cannot have an opinion. But every number carries the assumptions of the person who made it. And when those assumptions are wrong, the number is a weapon. In February 1998, before Sally Clark was even charged, before she had ever seen the inside of a courtroom, before the trial, before the first appeal, before 3 years of prison, a set of laboratory results came back from Macclesfield Hospital to Dr. Alan Williams. Those results showed Staphylococcus aureus at 8 sites on Harry Clark's body, including his cerebrospinal fluid, with polymorphs indicating infection during life. A natural cause of death, sitting in a file, unread by anyone except the man who had ordered the tests. Williams made a decision. He decided the results represented post-mortem contamination. He decided they were not relevant, and then he said nothing. He said nothing at the trial. He said nothing when the jury asked, specifically, whether blood test results existed for Harry. He said nothing at the first appeal in October 2000. He said nothing for 5 years, across every stage of a process that sent an innocent woman to prison and destroyed her health permanently. When the GMC finally asked him to explain, Williams said he believed his brief summary phrase, "no evidence of acute infection or inflammation," had adequately covered the matter. He said contamination was a reasonable interpretation. He said if the defense had wanted the results, they should have asked. He was given the opportunity to address the court to explain his decision to withhold the laboratory results. Court of Appeal Judgment, 2003. He declined. This is not a story about one bad actor. This is a story about what happens when a disclosure system has no enforcement. When a pathologist can decide, unilaterally, what is relevant and what is not. When nobody independently verifies what tests have been run, what results have returned, and what has been shared with both sides. The defense in Sally Clark's trial did not know the tests existed. They could not ask for results they did not know about. By the time Stephen Clark found the file, after years of reading through 1,000 pages of hospital records himself, on his own time, without legal funding, his wife had already served her sentence. Why it cannot be overlooked? Because this is not ancient history. The principle that a pathologist can self-certify a test result as irrelevant, without showing anyone else, was only explicitly challenged in the High Court ruling on Williams's own case in 2005. Disclosure protocols in forensic pathology were strengthened after Clark, but strengthened is not solved. Auditing what tests were run versus what was disclosed remains a gap in criminal forensic procedure that defense teams must actively fight to close. The law professor's observation cuts to the bone. A defendant should not have to spend years in a prison cell, systematically reading hospital records to prove the prosecution concealed the evidence of their innocence. The system should find it. The system failed, and the gap it left is still there. The prosecution in Sally Clark's trial did not just present medical evidence. They built a character. They described Sally Clark as a lonely drunk, a career woman who had been pushed over the edge by the demands of caring for young Bobbies. They implied she resented motherhood. They suggested that her return to work, her professional ambitions, her composed demeanor in court, all of it was evidence of coldness, of something missing, of a woman who did not feel what a real mother should feel. The tabloid press amplified this portrait with enthusiasm. Here was a woman who looked professional, who did not weep on command, who answered questions with the trained composure of a solicitor. And to the press and to the jury, that composure became suspicious. If she were innocent, they reasoned, she would look more broken. But Sally Clark had already buried 2 children before she ever set foot in that courtroom. She had been arrested while pregnant with her 3rd. She had lived with the accusation for over a year. She was not unbroken. She was simply not performing her brokenness in a way the room expected. This is a failure that predates the Sally Clark case by centuries. It is the expectation that grief has a correct appearance. That innocence can be read in a woman's posture, in the pitch of her voice, in whether she cries in the right moment in front of the right people. It is a standard that has always been applied to women in particular, and to mothers with particular ferocity. The Medico-Legal Journal warning of 2004, published after Clark's release, the journal explicitly warned, "Beware the adverse and false inference. Sally Clark was a career woman, therefore her surprise baby was an inconvenience." It named this as a distinct failure mode, the use of lifestyle as evidence of motive. Angela Cannings, Trupti Patel, Donna Anthony. Every woman in this pattern was also described in terms of who she was rather than what she had done. Their grief was measured against a template. Their lives were examined for evidence of inadequacy. And when investigators found none, because there was none, the absence of evidence became, in a terrible inversion, evidence of concealment. A neighbor who knew Sally Clark said after the conviction, "None of us believe she is guilty. She is such a lovely person." But the jury had not heard from neighbors. They had heard from doctors. Why it cannot be overlooked? Because the assumption that a mother who does not perform grief correctly must be hiding something is not a legal argument. It is a prejudice. And it is a prejudice that still shapes how juries perceive female defendants in child death cases, in domestic violence cases, in any case where the woman's emotional response to tragedy is placed under examination. The fact that Sally Clark was a solicitor, someone who knew how to manage her presentation in a professional context, was used against her. Competence became suspicious. That is the logic of a system that has already decided. The prosecution called her a lonely drunk. The people who knew her called her a loving mother. The jury listened to the prosecution. We should have listened to the people who were there. The First Court of Appeal in this case knew the statistics were wrong. They acknowledged it. They said so. And then they upheld the conviction anyway. They ruled that the other medical evidence, Dr. Williams's post-mortem findings, the revised pathology, the expert witnesses, was, in their assessment, sufficient to sustain the guilty verdict even without the flawed statistics. What they did not know, because no one in the room knew, was that the medical evidence was also compromised. That the results from Macclesfield Hospital existed, unread by the court, unread by the defense, pointing to a natural cause of death. The court reviewed flawed evidence, acknowledged it was flawed, called the remaining evidence overwhelming, and that remaining evidence was concealing the truth. Two independent failures, stacked on top of each other, and an appeal system that closed the first window before the second was visible. This is a structural problem, not a human one. The appeals system in England and Wales is not designed to investigate cases from scratch. It is designed to review the process by which a conviction was obtained, to check whether the trial was conducted fairly, whether the law was applied correctly, whether the evidence presented was properly handled. What it is not designed to do is find evidence that was never presented at all. The First Appeal Court had no tools to discover what they did not know existed. Their failure was systemic, not personal, which makes it harder to fix and more important to name. Why it cannot be overlooked? Because the First Court of Appeal's decision to uphold a conviction on overwhelming evidence that was itself compromised held for over 2 years. Those were 2 years of Sally Clark's life, 2 years of her husband's, 2 years of her surviving child growing up without his mother. The mechanism that allowed one bad ruling to survive that long is still fundamentally intact. Appeals review process, not truth. And process can be followed perfectly while truth remains buried. The Criminal Cases Review Commission was created precisely because the courts cannot always self-correct. It was established in 1997, 2 years before Clark's conviction. Since its creation, it has referred 650 cases back to the courts, and more than 420 of those appeals have been allowed. 420 convictions that the courts themselves had upheld and then, on second examination, could not justify. That number is not a success story. It is a measure of how often the first line of review, the Court of Appeal, says a conviction is sound, when it isn't. When the machine that is supposed to catch mistakes makes a mistake, and then protects that mistake, the only person left to correct it is the person it is destroying. And sometimes, they run out of time. On January 29, 2003, Sally Clark walked out of the Court of Appeal, and the world was told that justice had been done. The wrong had been righted. The system had, eventually, corrected itself. The narrative of institutional self-repair was complete. 4 years and 46 days later, she was found dead. Her family described a woman who had been diagnosed with enduring personality change after catastrophic experience, protracted grief reaction, and alcohol dependency syndrome. These are the clinical terms for what the justice system did to her, not what happened to her by accident, not the unforeseeable aftermath of an unusual experience. What the system did, and then walked away from without looking back. Angela Canning said something that should be carved somewhere visible to every appellate judge who has ever written the word exonerated. Nobody came. When she was freed, nobody from the authorities came to her door. No police officer, no social worker, no doctor who had been involved in her case. Nobody came to check whether she was all right. Nobody came to help. She and her family came to the authorities 4 months later and asked for help themselves. The Clark family had no reason to expect anything different. It's almost, oh well, she's free, go home to your husband, you will be fine. It's so wrong. Angela Canning's 2007. Sally Clark was 42 years old when she died. She had spent her professional life believing in the law. She was the daughter of a police officer. She had trained as a solicitor. She had placed her trust in the system not as a naive bystander but as a practitioner, as someone who had studied it, worked inside it, dedicated years to it. And the system she had believed in had branded her a child killer in every national newspaper, sentenced her to life imprisonment, kept her in a prison cell for 3 years, and then opened the door and said, "You're free. Off you go." There was no restorative process, no formal apology from the institutions that had failed her, no state-funded psychiatric provision that reached her before she died. The men whose evidence destroyed her continued their careers, their public lives, their professional standing. One of them was reinstated to the medical register by a 2-to-1 court vote. He stood outside the Court of Appeal and said he was glad the court agreed with him. Why it cannot be overlooked? Because in the years since Clark's death, other wrongfully convicted people have left prison to face the same wall of silence. Exoneration removes a legal status. It does not restore a life. It does not undo 3 years of being treated as the lowest form of human being in a prison system. It does not restore the professional reputation that was destroyed in every newspaper in the country. It does not bring back the years a child spent without their mother. The justice system needs a restorative mechanism that does not currently exist, not as a courtesy, but as a legal obligation. Exoneration means the law admits it was wrong. It does not mean the law fixes what it broke. And the difference between those two things is a woman's life. After Sally Clark's release, things changed. Some things. The Kennedy Report of 2004 established new national protocols for investigating sudden unexpected deaths in infancy. Expert witness guidelines were strengthened across the English legal system. The criminal procedure rules were updated to require better disclosure of expert evidence. The Court of Appeal, in the Canning's ruling, established that no mother should be convicted of murdering her children when medical science cannot determine the cause of death. These are real reforms, they matter. They were won at enormous human cost. But the mechanism that produced Sally Clark's conviction was not a single exploitable loophole that could be closed with a protocol update. It was a culture in which the confidence of an expert was treated as more reliable than the evidence beneath it. A culture in which the grief of a mother was treated as a forensic puzzle to be solved rather than a human experience to be witnessed. A culture in which disclosure was, in practice, optional for the side that controlled the evidence. Protocols address behavior. They do not address the assumptions beneath behavior. And those assumptions about authority, about grief, about guilt, persist long after the paperwork is updated. 1 sudden infant death in a family is a tragedy. 2 is suspicious. 3 is murder unless proven otherwise. Roy Meadow, Meadow's Law, still cited in academic literature as late as 2025. That dictum was never formally abolished. It was discredited. It was criticized. Papers were written about its dangers. And then, because a discredited idea, said confidently enough by the right kind of person, has extraordinary longevity, it continued to circulate. As recently as 2025, legal scholars were still having to actively argue against it in published academic work. The harm that bad science does is not limited to the case in which it is first deployed. It propagates. It becomes precedent. It becomes assumed wisdom. And dismantling it requires not just a court ruling but a sustained cultural commitment to examining the foundations of what the system has been told to trust. Why it cannot be overlooked? Because of those 297 cases reviewed after Sally Clark's release, not all were overturned. Some of those convictions stood. We do not know with certainty which of those were just. We do not know how many women in the UK, in the US, in Australia, in every country that imported the intellectual framework of Meadow's certainty, are still serving sentences for deaths that were not crimes. The reform was real. The confidence that it was sufficient would be premature. There is one more number worth considering. The CESDI study that Meadow used to derive his 1 in 8543 figure. The study he then squared to reach 73 million. That study did not just provide a risk number. It explicitly stated that there may be unknown genetic or environmental factors that predispose certain families to SIDS, making a second death within the same family far more likely than in a random family. That caveat was in the study. Meadow did not cite it. He was not asked about it under cross-examination. The jury never heard it. The information needed to dismantle his argument was already in the document he used to build it. The lesson was always there. The question is whether anyone was asking the right questions, and who paid the price when they were not. 7 warnings, 7 mechanisms, 7 ways the system failed one woman, and in failing her, failed every person who will ever stand in a courtroom without the resources, the connections, or the husband willing to spend 4 years reading through hospital files to find the truth. Sally Clark's father, Frank Lockyer, spent his life as a police officer. He had trusted the system he worked inside for decades. After what happened to his daughter, he filed the complaint that brought Roy Meadow before the GMC. He did not do it out of anger alone. He did it because he had been trained, his entire career, to believe that the system could be made to account for its failures, if someone was willing to hold it to account. He was right, and he was also too late. The lesson of this case is not that the justice system is beyond repair. It is not nihilism. It is something harder, the recognition that every institutional safeguard is only as strong as the people willing to insist on it. Every disclosure rule requires someone to actually verify that disclosure has happened. Every expert witness protocol requires someone to actually challenge the expert. Every appeal mechanism requires someone to actually find what was missed. Stephen Clark found it. The CCRC acted on it. The Second Court of Appeal did the right thing. But it took 5 years, one man's obsession, and the near total destruction of one family to get there. Sally Clark said when she walked free, "There are no winners here." She was right, but she was also speaking a truth larger than her own case, because the system that failed her is still running. The mechanisms that produced her conviction are not extinct. They are dormant until the next case, the next number, the next expert with unquestioned authority and a theory they are certain about. The warnings this case leaves are not warnings for lawyers or judges alone. They are warnings for anyone who has ever sat in a jury box, For anyone who has ever heard a number delivered with confidence and assumed it was true. For anyone who has ever watched a grieving woman and wondered silently, uncomfortably, whether she was grieving in the right way. From an investigative standpoint, the parallel is not rhetorical, it is structural. The case of Sally Clark collapsed because a jury was persuaded by authoritative but fundamentally flawed expert interpretation, most notoriously the one in 73 million statistic and undisclosed medical evidence, later exposed as a miscarriage of justice. And today, in the case of Lucy Letby, we are again seeing a conviction heavily anchored in contested expert testimony, now being challenged by multiple independent specialists who argue there is no reliable medical evidence of murder and attribute the deaths to natural causes or systemic clinical factors. Critically, this underscores how a justice system, when overly deferential to perceived expertise, can effectively weaponize bad science and misapplied statistics to construct a narrative of guilt that appears rigorous, but is fundamentally unsound. The enduring risk is epistemic inertia. If appellate scrutiny, disclosure discipline, and evidentiary standards do not internalize the lessons of Clark, then Letby's case may not merely echo history but replicate it, exposing a persistent institutional vulnerability to wrongful conviction. Through the shadow lens, we do not examine these cases to frighten you. We examine them because the alternative, not examining them, filing them away under resolved, calling the reforms adequate and moving on, is exactly what the system does. And we have seen what happens when the system does that. We have seen what a 42-year-old woman looks like when a justice system decides it is done with her, before she is done surviving what it did. These warnings are Sally Clark's. She paid for them. The least we can do is hear them. Through the shadow lens, we examine the darkest crimes and the secrets hidden behind them. And tonight, the darkest crime in this story was not charged. It was not prosecuted, and no one served a day in prison for it. We want to hear from you. Of the 7 warnings this case leaves: the authority problem, the corrupted statistic, the buried evidence, the grief misread as guilt, the system protecting itself, the hollow exoneration, the lesson learned too slowly, which one unsettles you the most? Tell us in the comments, and tell us why. Because this channel exists in that space, the space between what is reported and what is understood, between what the verdict says and what the truth was. Sally Clark was 42 years old. Her 2 Bobbies were 11 weeks and 8 weeks when they died. Her surviving son was at school when his mother was found. "There are no winners here," she said the day they freed her. She was right. In our next investigation, we go inside a case that begins where this one ends, with a system that had been warned, that had seen what expert overconfidence produces, that had promised to reform, and then, in a different courtroom in a different city with a different name on the dock, did it again. Only this time, science was also abused just as statistics, a technique used in hundreds of British criminal trials, treated as settled science for decades. And then quietly, almost without announcement, found to be unreliable. The question it raises is the same one Sally Clark's story raises. If the science was never sound, how many of those convictions were real? We'll see you in the shadows.